Okay, I'll get started then. Firstly, hello and welcome. I want to thank the panelists and all those who made time today to join us. My name is Erin McKay, and I am Oxfam's campaign manager for the European Migration Response, which is a regional response implemented by Oxfam in Greece, Italy, the Balkans, and Spain to assist migrants and refugees. This week marks 5 years since the EU-Turkey deal was brought into effect. Along with our partner, Refugee Rights Europe, we are very happy to bring you this conference today to discuss the impact of this deal on the Greek islands and the future for EU refugee response at European borders. The EU-Turkey statement was the beginning of the containment policy we see in place on the islands. And while there are debates about whether the deal itself was useful or not, there is consensus that the overcrowding and suffering in the camps has to end. There are currently 16,150 refugees and asylum seekers who reside on the Aegean Islands. Of those, 12,150 reside in the permanent and temporary reception and identification centers. These policies have had real-world implications on the men, women, and children trapped in hotspots, and we hope to encourage a dialogue here today about the way forward. I will now hand over to Stephanie Pope, Head of EU and UN Policy and Advocacy for Refugee Rights Europe, who will be your moderator this afternoon. Thank you.
Yes, thank you very much, Erin, and hello everyone. We're very pleased you've all joined us today. As we all know, over the past years, the EU-Turkey agreement and the related migration management approach on the Greek islands have been a cornerstone of the EU's asylum and migration system. Following the announcement of the agreement, the EU hotspots on the Aegean Islands, which were originally conceived as open reception and identification centers, changed in their function to become sites that were to facilitate the implementation of the agreement. The related geographical restriction and containment policy, combined with the lack of effective responsibility sharing from other member states, most notably in the form of relocation, resulted in bottleneck scenarios in the hotspots, with well-documented human rights consequences, as Erin has already referred to. From severe overcrowding and a sustained failure to provide reception conditions in line with EU law, to delayed and complicated asylum procedures resulting in part from the introduction of a so-called admissibility procedure aiming to implement returns under the EU-Turkey agreement. In addition, what could be described as rather intransparent and convoluted governance of these sites has contributed to what the director of the EU's Fundamental Rights Agency, Michael O'Flaherty, once described as the, quote, single most worrying fundamental rights issue we are confronting anywhere in the EU, when referring to the former Moria RIC on Lesbos. Now, 5 years since the announcement of the agreement, we are at what could be considered a crossroads. As the European institutions are negotiating the European Commission's proposals in the new Pact on Migration and Asylum, and simultaneously, after 5 years of experience with the EU hotspots on the Greek islands, the European Commission and the Greek government have announced plans for new multi-purpose reception and identification centers on the islands that are to be operational from September of this year, including the publication of a memorandum of understanding for a joint pilot site on Lesbos. Meanwhile, several proposals in the new pact, in particular with regards to the new screening regulation and the border procedures, appear closely related to the procedures that have been developed and tested in the RICs on the Greek islands in recent years. And similarly, depending on the outcome of negotiations, certain proposals in the new pact may be implemented in these new centers in future, and the centers may become the blueprint for further such sites at EU borders. So today, 6 months before the new centers on the Greek islands are to be operational, we aim to bring together relevant policymakers in European institutions and agencies, as well as members of the Greek government, NGOs and civil society, to exchange on these plans and discuss how the human rights shortcomings of previous years can be avoided, both in terms of procedures and conditions in reception centers at EU borders, as well as in terms of their governance. So a few words on technicalities before I introduce our first panel. Please note that today's event will be recorded, and as always, we kindly ask all speakers to please mute themselves when they are not speaking. And to the audience, we encourage you to please submit your questions throughout the panels using the Q&A function at the bottom of your screens. And please indicate clearly which speaker your question is addressed to. We are monitoring these questions throughout the event and will address your questions to speakers in the Q&A section after each panel. So with that, I'll move us on to our first panel, during which we'll examine the procedures carried out in the EU hotspots on the Greek islands and potentially in the future multi-purpose centres in more detail, as well as the key safeguards that must be ensured based on the experience of the past 5 years. Our first speaker is Mr. Minos Mouzourakis, Legal and Advocacy Officer at the NGO Refugee Support Aegean, who will be offering his insights based on RSA's on-the-ground experience over the past years. And I would like to briefly highlight that RSA recently published a legal note on the rule of law impact of 5 years of the EU-Turkey agreement, as well as a joint NGO report comparing the current Greek reception and identification procedure with the proposed screening regulations. So we encourage you all to familiarize yourselves with these outputs, which I'm sure Minos will be glad to provide upon request. So with that said, Minos, over to you.
Thank you very much, Stephanie, and good afternoon, everybody. Thank you for organizing this discussion, which, as you said, is extremely timely given developments at EU level. When it comes to the workings of the procedures on the islands, of course, there are perhaps a few clarifications and disclaimers to be made. What I will try to do with you today is to focus on the first segment of procedures, which relates to the so-called reception and identification procedure that is set out in Greek legislation, namely Article 39 of the International Protection Act. Roughly speaking, this would be the equivalent of the screening procedure that is put forward by the Commission in the screening regulation proposal as part of the pact. And even though we are only in a Commission proposal phase, there are still certain elements that might appear to be tested in the form of pilots in the Greek context, in specific reception identification centers, RIC, either in Evros or on the islands. So to keep it neat and short insofar as possible, what I would propose to do is to briefly look at a couple of issues and potential pitfalls in the procedure that might be worth taking into consideration, and perhaps close with a set of conclusions for the screening proposal specifically, and for the work that the EU co-legislators will be bringing forward in the coming months, if not years. So the reception identification procedure is applied on the islands and at the land border in the reception identification centers set up for that purpose. The idea is, as we know, to make sure that people arriving irregularly are sufficiently and adequately registered, identified, screened medically and for vulnerability, undergo security checks and so forth, before they're channeled into an appropriate procedure. Two of the prominent issues that we've seen over the past 5 years, and as Stephanie mentioned, these have also been highlighted in publicly available documentation, relate on the one hand to the way registration is conducted, namely on the role of EU agencies in supporting the national authorities, and secondly, on the critical issue of medical checks and vulnerability assessments. So when it comes to registration, domestic legislation stops short of regulating the exact modalities of how EU agencies provide their support to the domestic authorities. These are regulated by standard operating procedures, which of course are not publicly available. What we see in practice is very often difficulties and errors when it comes to the registration of personal data of individuals that undergo the reception and identification procedure by experts that are deployed by Frontex to support the Greek authorities. And that includes crucial data such as nationality and age, including in cases where the declared age or nationality of the person may not be recorded, but different details might be put down on paper. One of the key procedural pitfalls of the whole process is that this procedure carried out in front of a Frontex deployed expert is neither recorded nor transcribed. meaning that the person does not have ready access to the information that has been taken into account, with palpable impact on their procedure. The impact, I think, cannot be understated, given that this has bearing not only on asylum procedures, but also on the Dublin system, namely in terms of family reunification and eligibility for transfer to other member states. Secondly, related to the amply discussed question of vulnerability assessments, one of the problems that civil society and practitioners on the ground have seen quite consistently is that there seemed to be a difficult correlation, let's say, between the vulnerability assessment and medical check and the reception and identification procedure, in the sense that very often that first screening procedure is deemed to be completed and the person has been referred to the asylum service to start the asylum procedure without having undergone a medical check and or a vulnerability assessment. This may be due to capacity gaps. And there, I think it's crucial to highlight that when speaking of capacity, we're not only speaking about asylum authorities, about Frontex EASO, we're also speaking about public health institutions that are located based on those different points where those procedures are implemented. So this is indeed a holistic approach to governance and a combination of different authorities. Other issues that stem from this that are quite understandable are long waiting times for the conduct of vulnerability assessments. Very often non-identification of vulnerabilities, specifically those that are not immediately visible. Survivors of torture are a crucial category in this regard, and there's a lot of literature that highlights those difficulties. And also failure to refer individuals to specialized examinations at hospitals when this is needed. So in conclusion, when it comes to the screening regulation proposed by the Commission and how we take that forward, these are smaller details and issues that are of course to be discussed by and within the co-legislators as they progress in terms of negotiation. What we would need yet again to highlight is also the broader picture. We have stated our position quite clearly since the publication of the pact. And for us, the added value of the Commission proposal has yet to be established and has yet to be proven. And we think the onus remains, of course, on the Commission as the institution that proposes legislation to explain why we need this particular proposal for points of entry in the EU. Why do we need the fiction of non-entry, which will mean deprivation of liberty en masse at points of arrival? It will also mean massive containment at borders, like the situation that we've seen over the past 5 years. This is also highlighted by the Greek government and by other member states in their position on the pact. And in any case, why crucial safeguards, not only when it comes to legal assistance, to the very often discussed issue of monitoring mechanisms, but also the conduct of EU agencies that will definitely have a key part to play, are not sufficiently regulated in legislative standards as would be mandated by the rule of law. I will leave it at that, but look forward to the discussion. Thank you very much again.
Thank you very much, Minos, for these reflections and also for the recommendations. I'll now pass on to Ms. Anne-Charlotte Nygård, who is Head of Unit Technical Assistance and Capacity Building at the EU Fundamental Rights Agency. The agency has engaged in fundamental rights monitoring in the EU hotspots over the past years and is included as an actor in the aforementioned Memorandum of Understanding for the new joint pilot on Lesbos. So, Ms. Nygård, the floor is yours.
Thank you. Thank you very much. Thank you for the invitation to take part in this event, which is both important and timely for, I think, the reasons that you outlined in the opening. I will speak a few words about the proposed screening regulation and also link some of the items to what we have experienced and what we have learned ourselves through our work in Greece in the past few years, and notably in the context of the proposed centers that were referred to earlier. So the proposed screening regulation, it applies to people who cross the external border irregularly. It applies to those who have been disembarked, and it applies to somebody who at the border crossing point applies for international protection without fulfilling the conditions of entry. And it also applies to those apprehended within the territory to compensate for the fact that they have so far managed to avoid border checks, but it does not apply to overstayers. I will raise a few fundamental rights concerns that we have identified in a so far rather superficial analysis. And to go further, of course, one need to draw final conclusions. One need to make a more exhaustive analysis. But these are some of the fundamental rights implications. First, screening proposals, they refer to a situation of non-entry. The person is not authorized to enter the territory. So what does this mean then in the context of detention? Because according to recital 12 of the proposal, in individual cases where required to prevent the entry, detention may be allowed subject to national law regulating the matter. So in light of the legal situation of non-entry established by the screening proposal, the safeguards in relation to detention that we see in the Reception Conditions Directive, they cannot apply. But both the Reception Conditions Directive and its recast only apply to those who made an application on the territory, as long as they are allowed to remain there. But standards under the European Convention on Human Rights and the International Human Rights Law standards, they apply because the person remains under jurisdiction of the member state. Then, during the screening itself, all persons concerned should be guaranteed a standard of living complying with fundamental rights, since the member states are implementing EU law in this context, and this applies irrespective of the legal fiction of non-entry. This is echoed in recital 27 of the proposal, and it means access to emergency health care and essential treatment of illness. And in Article 9, particular attention should be paid to vulnerable groups. Let's now for a short while turn to the plans for the multipurpose reception and identification centers in Lesbos, Greece, and the MOU on the joint pilot on this, which has been concluded between Greece, the European Commission, and GA, just the Home Affairs agencies, some of them. FRA has developed a list of fundamental rights considerations for the creation of the new centers, and they were, of course, developed in light of the present legal situation and did not, of course, not consider any proposed screening rules. I will just mention 3 points that the FRA raised here. First, the need to apply the standards as laid down in the Reception Conditions Directive. These are important safeguards. And we also referred here to EASO guidance on the reception conditions to further support implementation. We refer to the need to respect the right to liberty. The centers and the services offered should be planned to allow asylum seekers to enter and exit the camp, as well as to move freely inside it. We refer to the targeted responses needed when addressing vulnerabilities. There will be some individuals, for example, unaccompanied children, victims of domestic violence, people with serious illnesses, whose vulnerability require the transfer to alternative housing away from the centers. Then, if we then look further into some of the aspects of the screening rules, let's look at the authorities that the member states must designate, and particularly the staff there. Qualified staff is a starting point if trying to avoid protection risk, and the proposal speaks about appropriate staff and sufficient resources, but it is silent on the qualification of staff. Staff should be required to be well trained in identifying asylum application or victims of human trafficking. Even if under Article 14, the screening authority should indicate to the asylum authority whether the application at first sight should be processed in an expedited manner. And this poses a protection risk. Then the procedural safeguards seem insufficient. The duty to inform is minimalistic and formal. The rule is to give written information and not orally, and this is unlikely to be effective. This is what we have seen when involvement of specialized agencies. Clearly a good practice from the hotspot is allowed, but it's not encouraged under Article 8. There is no duty to involve interpreters during the screening, and without adequate interpretation, the current gaps in identifying asylum applicants, assessing nationality and statelessness or family links will remain. There's no mention that lawyers, legal counsel, or guardians can accompany the person during the screening. Strengthening the safeguards to have access to legal aid is even more important in the setting, given that the defense possibility for the applicants are more limited in border areas at remote locations. The outcome of the screening will not result in a formal decision, but a debriefing form. And in case of erroneous referrals to return procedures, non-referral to an asylum procedure where it should have been, or a wrongly refusal of entry, there is a risk that the principle of non-refoulement could be violated, and this is a first point for a right to remedy. Then in a few words about the involvement of child protection authorities. The recitals refer to the best interest of the child, and author articles refer to the involvement of child protection authorities. However, their particular role in the context could be further clarified. Then my sixth point here is about the use of EU IT system and in the way that they work in an interoperable manner, because the biometric data of the applicant should be checked against the common identity repository, and which will allow checks against EES, VIS, ETIAS, Eurodac, and ECRIS TCN in one go. Based on our previous research, we can here see essentially two risks. This is that the risk of self-harm to avoid fingerprinting is likely to continue to remain a concern here also, although technology is developing and now deep fingerprint scanning prevent that fingerprinting can be avoided through self-harm. False biometric matches are rare, but they can happen, and we have to keep in mind the particular vulnerability of the persons concerned in the border procedures, and the match that can be taken, a wrong match that could potentially be against a serious criminal or a terrorist. Now, finally, FRA is envisaged to support the member states in the setting up of an independent national monitoring mechanism. First, if we start with Article 7, it obliges member states to set up an independent monitoring mechanism to ensure compliance with EU law, international law, and the Charter during the screening. And FRA, of course, welcomes this proposal and our also proposed engagement. We support that the monitoring is carried out by national actors. This allows adjustment to the realities on the ground and to build on the work of national human rights institutions and national preventive mechanism. It is a clear statement that the monitoring must be independent, and establishing independent monitoring mechanism at borders has proven a useful tool for states to ensure that border control activities comply with fundamental rights. Monitoring can help to identify problems, gaps, and training needs. It can also increase transparency on the fundamental rights situation at the borders and help address deficiencies and facilitate investigations. The duty to investigate allegation of fundamental rights is something that we also welcome as well. The proposal gives the role to FRA to support member states in the establishment of the independent monitoring mechanism through providing guidance, and also through supporting member states in regards to safeguards for independence, as well as the methodology, establishing the methodology for the monitoring. And of course, FRA is then ready to support the monitoring mechanism with capacity building activities in the form, the modalities that the EU legislature will eventually entrust to us in this context. So I'll thank you very much, and I'll stop here and look forward to the question and answer session.
Thank you very much, Ms. Nygård, for these very detailed reflections. And a brief reminder to the audience to please send your questions through using the Q&A function at the bottom of your screens, as there will be a Q&A section after each panel. So I'll now pass on to our final speaker for this first panel, MEP Birgit Sippel of the S&D Group and member of the Committee on Civil Liberties, Justice and Home Affairs, who is also the rapporteur on the proposed screening regulation and who will be offering her comments on the proposal now. Ms. Sippel, over to you.
Thank you very much. And maybe I should start really with my first thoughts when I first went through the text. And my first question really was, oh, is there anything new in this so-called new pact? Or is it simply that we legalize, or maybe let's say confirm what already can be seen, for example, on the Greek islands? And is it really that what we want to see? Going more in detail through the text, clearly, I only can agree. I'm not sure about the true added value of the screening regulation. You know, it should be based on the Schengen acquis, not on the asylum acquis. And therefore, I'm wondering if the screening regulation could not have been part of the upcoming Schengen Borders Code reform instead of that. And also, I wonder why this selected instrument is called a regulation, as many of the provisions are left up to national implementation by the member states. So these are some first questions. An overarching question also relates to the scope and procedure of the screening process itself, and the related issue of what already has been mentioned, the legal fiction of non-entry and what it means in practice for all the people. And to very precise here, this could lead also, when you go through the text, to widespread detention of third country nationals only based on the question that they are trying to apply for international protection, which, by the way, currently is forbidden under Article 8.1 of the existing reception condition directive. So that's a legal question also here. The Commission text also does not specify where the third country nationals should be accommodated during the process, which of course is important both for the persons concerned as well as for the receiving member states at the external borders. And the text is not saying anything about the conditions of accommodation throughout this period. In addition, the administrative status of the screening, which the Commission calls a mere fact-finding exercise, needs to be analyzed, as it comes with implications about the introduction or the absence of legal remedies against the facts that are found during this screening. We also need to examine the implication of the screening regulation, as already mentioned by the colleague from FRA, on already adopted legislative text like visa, entry-exit system, ETIAS, and interoperability. It's not really clarified in the text. And finally, one of the most important elements of the proposal is, of course, the independent monitoring mechanism for fundamental rights set out in Article 7. And this is especially so in the light of the numerous very well documented allegations against the involvement against Frontex in the pushbacks that we have seen. And here again, we need to look closely at the scope and details of the monitoring mechanism to check, can it be an independent mechanism? And can it really ensure that it actually brings added value to it and is not only a kind of a fig leaf to hide behind it? In addition, we are discussing this proposal today in light of the 5 years anniversary of the EU-Turkey statement. And once again, I have to wonder if lessons learned from the statement and the hotspot approach were not taken in completely the opposite way. We already see many elements that are now proposed in the new pact in practice on the islands, and it has led to incredible suffering of part of vulnerable people, but also to an increase in anti-migration sentiment by the local population who feel that they are left alone with the challenges. And the question is, should the lessons we draw from this experience really be to export that model across the entire EU? And coming back to what Minos Mouzourakis has already showed, the text on the screening also doesn't answer how to better do the vulnerable checks, the health checks, or access to healthcare. This is not answered in the text as proposed by the Commission. What are we doing now in LIBE for the time being in Parliament? Now, first of all, we requested recently a horizontal substitute impact assessment for 4 reports of the so-called new pact, meaning the asylum procedures, the asylum and migration management, the crisis management, and the screening. And unfortunately, this again was necessary because the Commission presented her proposals without an impact assessment, contrary to promises from President von der Leyen, but we don't have the results by now. In the meantime, we are completing, together with the Commission, a detailed read-through of the text, as well as cross-references in the respective files, for example, on the connection between APR and the screening. One of the main issues discussed so far is the relationship between the screening and the existing, but also proposed asylum acquis, in particular with the reception conditions directive. And key questions would include how the existing reception conditions directive impacts on the proposal for screening or not only regarding the question of detention, but also about the safeguards guaranteed to asylum applicants and from which moment these safeguards are applied. So you might ask, are there any key amendments, key changes that we already can see? But to be honest, in all the meetings we had so far, we are finding more and more questions, loopholes in the text, so that by now it's really too early to talk about key amendments. But I believe that many of the points that I already mentioned will receive special scrutiny, not only by my own, but also by the shadow rapporteurs. And mainly this will include, of course, the monitoring mechanism requirements concerning the screening, provisions of information, the respective checks and outcome of the screening. So a lot of work is in front of us. And to be honest, unfortunately, I don't see that we will proceed very fast, having also in mind that the Council is not making progress, or is even asking for watering down even some elements. So I will stop here, and it will be interesting to hear some questions and remarks from everybody in the room. Thank you.
Thank you very much, Ms. Sippel, for a very concrete analysis of the content of the proposal, including the elements that are not yet clearly outlined, as well as the work the European Parliament is doing in this regard. I'd now like to move us swiftly on to our first Q&A section. So The first question will be for Minos Mouzourakis, and it states, what are your recommendations on the screening procedure in relation to vulnerable groups specifically?
Thank you very much. So without prejudice to the general reservation, as Ms. Sippel also very eloquently put it on the entire proposal, when it comes to using better vulnerability identification procedures, I think already the screening proposal of the Commission starts from a very restrictive and narrow point. There are references to evident vulnerabilities in such a way as to hint that the process should be limited to a very quick check, only of that which is physically and immediately visible to the national authority. I think we very well know that this means that people with very acute needs will fall through the cracks because it is those very particular types of cases of people that actually have the biggest difficulty navigating asylum procedures. And I would even add, given the inherent link of the screening regulation proposal to the APR as done by the Commission, that would mean that those people navigate border procedures. So already a starting point is that vulnerability identification needs to be decoupled from the very superficial notion of focusing on the visible and focusing on the immediately identifiable. I think you need a proper infrastructure, a system, and a process with the right people, with the right capacity, but crucially with the right environment. So if this is to be done in a context of deprivation of liberty at points of entry at borders, where capacity and infrastructure of local authorities is naturally not necessarily the strongest, because we're talking about a border zone, I think there are inherent contradictions
including LGBTI applicants, especially in a situation of non-entry?
I would like to mention two things here. In addition to what Minos just mentioned, which was also on vulnerable groups, which I agree with. The first is the qualification of staff to work on vulnerable groups, to identify them, and also to have that differentiation in responses to be applied, which is then the next steps, that a system is there where one needs to know how to channel various forms of vulnerabilities into various procedures, which could well be the case if that is the reason for the person had to leave, and something that need to be taken into account, but not necessarily.
Thank you very much. And then we have another question for you, Ms. Nygård, which states, according to the aforementioned Memorandum of Understanding, the EU Fundamental Rights Agency will have a role in the multi-purpose centres. However, it was not detailed. Is there more information that you could provide about FRA's role in these centres?
Yes, our role is here to provide advice and assistance to the actors on fundamental rights issues, and also to contribute to training activities in this context, and also to advise on relevant strategies.
Thank you. We then have a question for Ms. Sippel. Do you think there is a possibility that the screening proposal will be dropped by the Commission, as it is a proposal full of legal unclarities and loopholes?
To be very honest, I don't see much appetite from the Commission to withdraw things that they just presented. Nevertheless, what I see in the debates, as I indicated before, there are some gaps and loopholes in the text, and therefore we have to work on the proposal. It will not be withdrawn. Be more clear rules. And coming back, for example, to questions like health checks or finding out vulnerable people, there are no clear indications how to do that. There are no clear answers who should do it, what are the services that are in front to do all these checks. So there are a lot of open questions, and we will do our very best to improve the proposal. But once again, I don't see a possibility that the Commission will withdraw that proposal.
Thank you very much. We have another question for you, Ms. Sippel, that I have to shorten due to time. It is a testimony from a person who has worked in Greece since 2015. She has seen the pain of vulnerable people, but also of the staff volunteering and working with them. The question is, what is the proposal to alleviate the pressure from the Greek islands and make sure that the system becomes more fair in future?
I think there are two elements that we have to look into. The one element that already has been mentioned today is the question, how many resources regarding technical equipment, staff, services, money, how many resources do we have in the camps, in the environments to ensure that the checks and the services are run well. But there is also another element that is totally missing in the proposal of the Commission, and that's the question of relocation. So real solidarity to ensure that part of the asylum procedures for some of the incoming refugees, asylum seekers, are done in other member states. We don't even have a clear obligation that after an asylum procedure has been done, that at least then some refugees, asylum seekers could be sent to other member states. So this practical solidarity regarding relocation is totally missing in the proposal. And I'm afraid this is one of the big challenges in front of us.
Thank you so much. And I will squeeze in a final question for Minos, which reads, how long does it actually take to assess vulnerabilities? Will 5 days be enough?
Thank you very much. I think whilst bearing in mind that every case has its own complexities and its own particular needs, I don't think that the general 5-day rule can actually cover this adequately. There's very ample documentation and literature on how vulnerability intersects with the protection seeking process. And of course, exposure to trauma in all of its different forms, that includes experience of violence, rape, torture, and other forms. But it could also very well apply to what the FRA colleague mentioned earlier on SOGI claims. How can we expect people to immediately arrive on an island, let's say, or at a border post, and under very truncated procedures recount extremely traumatic or sensitive events that relate to the reason why they're seeking protection, in the absence of a protecting and enabling framework to do so? It's a very, very crucial aspect that goes really to the heart of border procedures. It really goes to the sort of incompatibility of extreme speed with appropriate processing. And to bring and steer the discussion back to existing EU law, which I think is a useful point, we might recall that the Asylum Procedures Directive already makes sufficient provision for special procedural guarantees exactly for those types of cases, acknowledging how difficult it is for somebody to come forward and recount those events. And it uses the terms in recital 29 of the APD, sufficient time to prepare the person to actually go through that process. So 5 days after you've arrived on shore is probably not sufficient time.
Thank you very much. Thank you also for all these excellent questions and exchanges. It's now time for our second panel, where we aim to examine the governance of the future multipurpose reception and identification centres in more detail, including issues such as access, independent oversight, as well as monitoring and accountability vis-à-vis EU institutions, civil society, and the general public. Our first speaker is Mr. Emmanuel Logotitis, who is General Secretary of Reception of Asylum Seekers at the Ministry of Migration and Asylum in the Greek government. Mr. Logotitis, thank you very much for joining us, and I'll pass over to you now.
Thank you very much for inviting. It is crucial for us in reasons for transparency and, of course, of being active on this dialogue for the Greek government to be a member of this dialogue and this debate. Just to know who we are talking with, I wanted to introduce myself. I'm a doctor myself, and I used to be the doctor of the RIC, the RIC, as we call it, of Samos for 4 years of my life. So I'm a guy who have signed a lot of vulnerabilities, and I cannot help it. I have to comment on what was being told in the previous session. I followed that really patiently and really with all my attention on what was there. I have to say that I signed myself personally with a stamp and my signature more than 2 or 3 or even 4,000 vulnerabilities in Samos. And I hope that anyone who is participating in this meeting will not have to stay in front of people coming to an island, asking for a vulnerability, one, second one, a third one, because vulnerability was misinterpreted in the past as the only ticket out of the island. So this thing has its complexity. I'm the guy who stands in front of a boat of 40 persons who all came, all 40 of them, with the same story concerning a really serious dental disease. One of these 40 persons had the disease. The other 39 just replicated the story that was being told during the travel to Greece. So vulnerability is really a complex issue. Yes, it cannot be addressed immediately. That is why in the new system that we try to establish, they will have some, in brackets, relaxation time before they start the procedure of registration and telling the story. But we have all to recognize that there is a lot of manipulation coming from the side of the applicant on the issue of vulnerability. Of course, we need experts, as Fra insisted on expressing, and we need the experts on the field. We need training on VOT assessment and LGBTQI issues and the rest. But still, we have to address also the issue of manipulation in the procedure coming from the side of the applicant, because the benefit of all this is huge. The vulnerable person will be moved fast, will get a decision on the mainland rather on the island, most probably will be moved to a flat, and there are some benefits other than those. So yes, we need to do something better than we used to do, and this is exactly what we are trying to do with the multipurpose rigs. Mrs. Sippel said that we need resources. Yes, but we not only need resources and we need a more humane space. We should all agree that the camps that we had in Greece, take Moria, for example, it was the biggest rig. It had a capacity of 2,500 people. It used to host 25,000. So one way is to do the procedures faster, in a way that are efficient. Fast is not always efficient. They have to be efficient. So we have to agree on the time needed. What is a quick but not dirty way to judge on asylum? So we need a quick and efficient way. This, we say from our side, that might last something like 6 months. Yes, but do we need more than 6 months to decide on the simple question on whether someone should get or should not get asylum? The multipurpose rigs are there to support this case, according to the current situation that we are facing concerning inflows and the rest. What do we mean by humane conditions? People are not sardines. They need free space. They need the right to go in and out, as it was expressed. So they will have this right. But for matters of safety and security in the camps, this should be regulated. Who goes in and who goes out? There is a lot of misunderstanding in this. We are talking about a vulnerable population. So we let them free to anyone's appetite. I don't know how many of you were on the field, but I remember an example and a story that I have to share with you of a guy who was a volunteer in Samos in Malagari back in 2016 and was accused by the community of the asylum seekers of being a pedophile. Then I personally asked all the volunteers to go to the police station to register themselves and wear a tag. Next day, 2 of my close friends, volunteers themselves as well, disappeared from the island. Took the first flight early in the morning from Samos Island and disappeared, closed their profile in Facebook, and never heard from them again. So there are many dangers coming from both sides. And since we are the ones that have to deal with all these dangers, we have to make it on a safe and proper and efficient way. That is exactly what we are trying to do. We create these new camps, call them regulated entry, whatever you want. It's not a matter of a name. You can call me Yorgos. I will not be like offended. The thing is who I am and what do I represent and why do I do what I do. It's not a matter of a name. So let's call them the regulated entry-exit camps. Do we agree that we should have a way to control who is getting in and who is getting out? Not only for the applicants themselves, but also for the people who are supposed to be there to help. Will they get a free entrance? No. So there are some things that are misunderstood in this whole debate because we put a little bit of our own prism of reality in interpreting what these regulations stand for and what we try to do. We are left with the problem. So we have to deal with the problem and we have to address all the issues together. We all agree that there is some safety issues in the camps. That is why the European agencies ask for protection. That is why many times a lot of members of the NGOs called for evacuation of a camp under a riot or some other violent incidents. We cannot evacuate, unfortunately. We are the Greek government and we are supposed to stay there and face all the difficulties. So we need to take all the preventive measures in order to make sure that the people inside the camp, volunteers, workers, or beneficiaries themselves are safe. That is what we are trying to do. Resources. Definitely we need more resources, both in personnel and also in equipment. The new camps will have all the medical resources in matters of equipment to do the basic check for vulnerability or for emergency cases. Do we need to have a laboratory in a camp? Yes, because as a doctor, I can verify you that for vulnerability, you need to have some laboratory testing. It is easier to have them inside the camp rather than in the local hospital, who was designed to serve an amount of persons less than the one it is called to serve now. That is what we are trying to do. I talked about space, I talked about recreation, I talked about sport facilities. I think that we all agree that this is needed, and this is what we try to do. Common spaces for food. I mean, all of us have seen these images of people standing in queues forever to wait for a simple plate of pre-made food. They deserve better, and this is what we try to do. That is the approach. Of course, we did what we could do in the asylum procedure. Now the asylum procedure in Greece is much faster than it used to be. People get a decision. And since we are talking about the pact, yes, it is a thing that it says nothing about relocation, but it does not say anything also for returns. Because you know, asylum is a procedure which has a result. The result is either yes or no. We all focus to the yes as if 99% will get a yes. No, generally speaking, 50% get a yes, another 50 gets a no. And no one is speaking about the no case. So I would be happy if in this dialogue concerning the multi-purpose rigs, because the people will be left there. It seems currently that with a no answer, there is a dead end. That is why Greece is not happy about all this asylum pact. What happens if they get a no? They get stuck in the island? They get stuck in the multi-purpose rig? They are returned back to Turkey? Today is the special day of the common EU-Turkey statement. But does it work currently? Does Turkey take people back? So, you know, when you are asking questions, it is easier. And I'm one of the guys who is supposed to give the answers to all this. But unfortunately, there are some answers that I cannot give. And the dialogue, when it concerns only questions, it is easy. We would like to have answers as well. What is Europe and all, I mean, Libe Committee and everything, thinks about returns? Should these people, if they do not, through a very efficient and very human procedure, they ask a question and the answer is no, what happens to them? I respect the thing about the Schengen rather than the asylum. But this is a different debate. If we agree on that, I mean, I will tell you another, I will reverse the question. Back in 2015, 1 million people passed through Greece. No one applied for asylum.
My apologies, Mr. Logotitis. I would just have to ask you to conclude within the next minute.
I will conclude. So the multi-purpose, going back to that, it is really difficult. That is why Beata is not smiling. It's really difficult for me to conclude coming to these interesting matters. But anyhow, on the multi-purpose rigs, this is the effort. It has been described as efficiently as we can. This is the effort of the Greek authorities with the joint partnership with the European Commission to give something better than we have now. The thing is that the capacity of these multi-purpose rigs is also limited. Why? Because in my country, we have seen times where even the capacity of 5,000 people in a multi-purpose rig is not enough. So we are not focusing that much on that, although it is a major thing that we are trying to build something better for the people together with the European Commission. We should focus back to the people. We try our best for the people with these multi-purpose rigs. We are open to proposals about how this should be done in a better way, but proposals get answers as well. Yes, and we will be happy to invite you to visit, all of you, whoever wants, one of these rigs, or to talk on a plan on how this should be designed, to have a debate on why we say something and you think something different. Thank you.
Okay. Thank you very much for your reflections and for the Greek government's perspective on these, what we know are very complex issues. I'd now like to pass on to Ms. Beate Gminder, who is Deputy Director General leading the Task Force Migration Management in the European Commission's Directorate General for Migration and Home Affairs. The task force coordinates the implementation of the joint pilot on Lesbos and other new reception facilities on the side of the EU. Ms. Gminder, the floor is yours.
Yes, thank you very much. And big apologies that I have been joining you late. I am sure you shared the moment that you want to throw out your computer out of your window as well. So I had one of these moments today. Yes, and thank you also for having the opportunity to be with you and to discuss this with you. Having said that, I'm the head of the task force, but what is this task force about? First of all, it's a small team in the European Commission. It's me and 3 collaborators, plus other people in DG Home who work depending on the topic with us. So we are a small task force, but of course we are having, a lot of input and effort also by the member states and particularly by the EU agencies. So it's also an effort to coordinate ourselves, our EU side of activities in Greece more efficiently. Because if I have to say and compliment what I've heard so far is, and my experience of the last 3 years with dealing with migration management in Greece, I think it's very important that all the stakeholders who want to improve the life of refugees and migrants and Greek citizens in Greece, because it concerns all the population there, that they cooperate and coordinate and talk to each other much more closely. Because I think over the last years, we have seen a system where there have been a lot of patchwork of emergency situations, and then also a lot of mushrooming of solutions, which, were the solution and a good solution at the time, but then, perhaps need to be revisited and brought back into a more systemic and systematic approach. And I think that's an extremely important part of the task force, that we try to coordinate on the EU side the efforts of the agencies, the efforts of the member states, and also the efforts of us in the European Commission, so that we can help as systematically, but also as needed within the Greek reception strategy in the Greek migration management. Therefore, also the dialogue and the cooperation with the government is extremely important, because, these 2 things have to mutually come together. But that's perhaps a bit more from a holistic approach, and also to explain what we are doing. Having said that, then coming also to the multi-purpose reception identification centers, I think it is really an effort to respond to what we've seen and what we do not want to continue, do not want to repeat on the Greek islands that are facing a particular challenge at the external border. Very general, of course, the EU acquis applies in these multi-purpose and reception centers. This was also just said by the Secretary General. The acquis, namely the Reception Condition Directive, namely the Asylum Procedure Directive, and of course also then the interpretation of them done through our Asylum Agency, and also of course the Charter of Fundamental Rights. We are still for Lesbos, which is the focus of the task force and the pilot, and where we have also signed a memorandum of understanding with the Greek government. We are still discussing the design of the new multi-purpose rigs. And we do this, as said, as EU, not only from the Commission side, but also with input from the Fundamental Rights Agency and from the Asylum Agency and from Frontex and Europol. They are also present in the islands. It's very important to safeguard the dignity of the persons that are arriving in the EU, but obviously we also are challenged by constraints that are the location, the environment, and also the not so easy cooperation with the local authorities, that after having been a very welcoming island, they have been badly, they are more and more, hostile to having any camp on the island, because they feel they have done their share over the past years. As the Secretary General said, these are open reception centers subject to entry and exit controls to monitor the whereabouts. This is important for security reasons. It's also important for follow-up on the asylum procedure. The entry and exit has to be at will. It's obviously possible to have curfews, like in any other possibilities, for example, closing it at night. But normally this is at will, and that's exactly like it is also handled in other member states. The rules on detention need to be respected. Article 8 of the reception conditions applies here. Applicants for international protection may be detained only under specific conditions, or as a last resort if other coercive measures cannot be applied effectively. Then, of course, at the moment, we're also dealing with Corona. Corona and COVID rules must be applied in a proportionate and non-discriminatory way. We have, as Commission, issued guidance to member states about that, and we have to have therefore given also a bit of a possibility for member states to act upon that. Having said that, I know that Greece is currently in probably one of the worst situations since I'm traveling to the country for quite a while. So possibility to restrict the freedom of movement is also always another question. Again, the Article 7 of the Reception Conditions Directives allows geographic restrictions, and in the Greek island case, this is linked to the EU-Turkey statement, as you know very well. In our memorandum of understanding, the MOU, we also have a quote, and I quote it here: reception conditions should be compliant with EU law and taking into account international standards and best practices. So we also specify that we should have safe zones for unaccompanied minors. That is a very important group for us, and we should have a separation between categories of applicants in terms of reception quarters, like accommodation or the sanitary facilities, and families or vulnerable persons or single women. Last but not least, also psychological counsel, medical services, classrooms, playgrounds, cooking facilities. The Secretary General mentioned that right now. All this is important to have a dignified environment. As I said, we have already talked a little bit already about the governance. Our MOU says we should ensure an adequate level of training, capacity, and planning, including a proper risk assessment and contingency planning, because this is essential to smoothly run a complex facility such as the envisaged multi-purpose reception centers. So I think that gives you a bit of an overview. I see there's many questions coming in, but I cannot reply them while talking. So I'll stop here and wait for your input. Thank you very much.
Yes, thank you very much. And we will have a bit of time, at least at the end, for some questions and answers. I will now pass on to MEP Tineke Strik of the Greens EFA Group and member of the LIBE Committee. Ms. Strik has recently published a commentary on the proposed monitoring mechanism outlined in the proposed screening regulation, and will be offering her reflections on potential monitoring and accountability mechanisms for reception sites at external borders. Ms. Strik, over to you.
Yes, thank you very much, and thank you for the organization. And it's always good at this day that we commemorate the signing of the EU-Turkey statement, that we really look at the consequences and the responsibilities on the Greek islands, because it's very closely linked, of course. Yeah. So actually, this is more about also the new pact proposals, but at the same time, we see a lot of deficiencies and non-compliance with the current rules already at the Greek islands. So I think it's good to address both of them, to see what needs to be done at a shorter term and in the longer term in the legislative pact, in order to indeed, what Mrs. Gminde said, having dignified circumstances and access to justice. But I will first focus at the screening regulation. What my colleague Birgit already touched upon, and also Minos, is the monitor mechanism that is proposed. And actually, it's one provision obliging member states to have an independent monitoring mechanism for the screening procedure. And what Commissioner Johansson often says then, that this is also meant and will lead to avoiding and combating pushback actions, which is really a persistent problem at the Greek borders as well, but also in many other external borders of the EU. Now, I think we really need to have a critical look at as to what extent this provision, if it will survive the negotiations and it will be adopted, will really end the pushback practices. I'm pretty concerned that this will not be the case, because the provision gives an obligation for a monitor mechanism specifically focused at the screening procedure as such. So that means a procedure which is conducted in a formal border crossing point or a facility like part of the pilot. And
as we know that pushback actions do not take place mostly, at border crossing point, at official points. I think what we know is that most pushback practices take place at spots where there are no eyes and ears, like in the forest, at sea, and so on. So I think first that we need to make sure is to expand the scope of these monitor bodies at all areas of the external borders. And I think Birgit already said that as well. We need to have more sufficient criteria in the screening regulation to make sure that there are sufficient resources, that there is sufficient mandate, and that there is sufficient level of independency. And we cannot take that for granted in all of our member states. And therefore, I think it would be really a major achievement if we get EU standards on this, so that the European Commission can also take measures in order to enforce compliance. So then you would have actually EU safeguards for national monitoring bodies in order to see and oversee what is happening regarding fundamental rights compliance at the border. I think, of course, that would be a major achievement, but I think still it would not be sufficient, because we need to have guarantees of what will be done with the outcome of this monitoring. At the moment, we already have a lot of pretty consistent reports about pushbacks taking place by NGOs, but also by ombudsman. And the problem lies there that national governments still tend to simply deny it because of a lack of evidence. And I think therefore, there should also be more guarantees that member states take this reporting, this outcome of the monitoring exercises very seriously, and doing a seriously examination of what has been reported. Otherwise, we're still left with empty hands. And furthermore, of course, in the end, we need a sufficient, consistent and credible action from the side of the Commission as a supervisory authority at the EU level to make sure that if one of those steps are not complied with by member states, that the Commission comes in and starts enforcing compliance, because this is what we already lack at the moment. If we address pushback action taking place, then every time, we see the Commission very much hesitating on what to do. First, they say we're not an investigative body and there's a lack of hard evidence. And second, we have to believe what member states say to us. And apparently, even if this answer of the member states contrasts all other reports of institutions and organizations. And I really think that because we rely on the Commission as guardian of the treaty, it's the only actor that can enforce compliance, that we really need another attitude and a more critical stance towards statements that are clearly not in line with all evidence that we have regarding fundamental rights violations. Furthermore, I would like to say, and of course this also relates to specific demands that we have regarding Frontex, because also Frontex needs to be more critical and have serious assessments of signals, any type of signal, if it comes to fundamental rights violations. But monitoring can never replace access to justice at the individual level. I think that's important to stress. And this is a shortcoming that we see in the screening regulation now. There is no, there are important decisions to be made over there. The referral decision can have huge consequences for the individual if you're referred to a border procedure or not. And also the information that is gathered over there and used for this referral information is of significant importance, like to see if, for instance, a safe third country principle or concept can be applied to a person. So you really need to have sufficient safeguards over there. You need to have legal aid, access to legal aid for the individuals, and you need in the end to have the possibility to object and to appeal against a referral decision. And the problem here, of course, again, is that the whole EU asylum acquis is not applicable in that stage. So, but regarding effective remedy, we do have the Charter of Fundamental Rights, of course, Article 46, which already implies that there needs to be an effective remedy in place. But I think really that the lack of application of EU standards in the asylum acquis is one of the big deficiencies of the whole screening regulation. And it also shows that it's very ambiguous. On the one hand, the Commission says there's really a need for harmonization, but on the crucial points, you see a lot of discretion for the member states. And this indeed regards also the reception conditions and the detention, specifically because the return directive also offers the possibility for member states not to apply the return directive in border areas. So if they decide not to apply the return directive, we don't have guarantees as to detention as well. And this is, by the way, also the case in the return border procedure, where you see that if member states do not apply the return directive, there are some articles of the return directive applicable, but not the grounds for detention. So that means that member states do have a lot of discretion in deciding if they detain persons or not. And then I may come to the next question as to how to monitor the pilot. The pilot includes all the different stages of what needs to happen at the border. And I think one of the problems, of course, is that you would like to have had a pilot before you have new legislative proposals. So it's a bit strange that we are already negotiating on text, whereas at the same time, parallel, we have a pilot going on. We do not have an impact assessment. What we have asked for, besides that we do a substitute impact assessment, what Birgit already referred to, we also asked from the Commission to have a kind of simulation exercise to have a better idea of what the consequences will be, how it will really work out in practice. But also for this pilot, of course, this is of utmost importance for us to see what will be the outcome. But the question that I immediately have, what criteria are applicable over there, specifically if it comes to the identification period, as the EU asylum acquis is not applicable in the regulation, but as we heard Mrs. Minos say, the reception conditions directive is applicable. But what then will it say in the end, as it is a pilot, about other national practices afterwards? Because it's not an obligation in the regulation that these standards will be applicable in other areas as well. So maybe that's a bit difficult for me. I think in order to judge if a pilot is successful or not, it should be really according to the rules that will be in place with the new pact. So this is something that we really need to take into account. I must say it's of utmost importance, but I really struggle as a member of the European Parliament to have sufficient oversight as to what is happening at the moment on the Greek island with the pilot, with the spending of the EU budget. Of course, we have invited Mrs. Gminda and we got a lot of information from her. But, we have then very tight time slots, and then we come up with additional written questions that we're still waiting for an answer after 4 weeks. So there is a lot of delay in when we ask for additional information in order to have a better monitoring of what is going on. So I think there's really room for improvement, and that we need to get this in order to also play a role, not only as a co-legislator, but also as controlling the Commission, and to put sufficient pressure on compliance with the rules, even also in a pilot stage. And the current situation, of course, where actually all EU standards are not complied with at the Greek islands. Thank you.
Thank you so much, Ms. Strick, for these comments. We are running over time a tiny bit, so If the speakers would be willing to stay maybe 2 or 3 extra minutes for some Q&As at the end, that would be super. I'll now pass on to our last panelist of the day, Mr. Matthias Mertens, who is co-founder of the grassroots movement Europe Must Act, currently based in Chios. Mr. Mertens will be offering a civil society perspective on plans for the new multi-purpose centres on the Greek islands, based on several years of experience on the ground in the EU hotspots. Matthias, over to you.
Yeah, thank you very much, Stephanie, for the introduction. Also, yeah, thank you very much to the other panelists. It's been very interesting to hear and learn from your perspectives. As Stephanie said in my intervention, I want to focus on the perspective of civil society organizations, and then in particular grassroots organizations, and their perspective from the ground, from the field, on the plans for the new multi-purpose reception and identification centers on the Greek islands. For years now, grassroots and NGOs and also refugee-led organizations have played a vital role in providing essential services, these ranging from healthcare to education, psychosocial care, legal aid, etc., and have been providing these to asylum seekers in the hotspot camps on the Aegean islands. And they have in fact been filling the service gaps left by, to be very honest, the government and authorities. In doing so, said NGOs, grassroots and refugee-led community organizations have built up extensive knowledge and expertise. We know what works, we know what doesn't work. We understand the particular needs and vulnerabilities of refugees and asylum seekers. We know how to effectively provide services in this context, and we have experienced over and over again the real-life consequences of decisions that are made in Brussels and Athens. The current moment, there's a lot of uncertainty about what the future role of NGOs in the MPRICs will be. An important side note to make here is that the space for NGOs and civil society to operate on the Greek islands is already shrinking, has been shrinking due to the ongoing criminalization of solidarity, and also an untransparent and quite arbitrary NGO registration system. Currently, NGOs have been provided with little information on how they will be able to continue providing their essential services within the context of the MPRCs. But what we do know about these new centers is major cause for concern, and I'm going to share three main points of concern here. We view the MPRCs as offering prison-like conditions. I had the opportunity to see the camp under construction on Samos myself, where there has been a very generous use of barbed wire and fences, even in areas designated as recreational spaces for children. There's also talk of high-tech surveillance systems that will use artificial intelligence to monitor the behavior of the people living in these centers. Another point of concern is the fact that these centers will be located outside of the urban fabric, in remote locations, hard to reach for NGOs, but also difficult for refugees to reach population centers and commercial centers to access services. And then another point of concern that has already been mentioned a few times is the controls on the mobility of asylum seekers to leave these centers. From our experience in the past few months, where there have been restrictive measures because of COVID on people living in the camp, is that these measures are often applied very arbitrarily, sometimes really depending on which guard is manning the guard station, the entry point that day. So this is very concerning for us. For us, in many ways, the MPRICs, they epitomize an almost total control over people's lives in these centers. They take away the agency of asylum seekers to access services independently outside of the centers and make their own choices. I in fact asked a colleague of mine who's an asylum seeker and has lived in a hotspot for many months, what life under such very strict conditions would be like, and his answer is as follows, and I quote, keeping people in captivity, keeping people trapped like this after all they have been through, after all the trauma they have suffered before even arriving on Greece. This will have a huge impact on people's mental health, with no ability for refugees to help themselves, to better their lives, better their living conditions, I mean. The centers will become pressure cookers where where tensions build, and where people are exposed to suffering and violence. As this is happening, as agency of refugees is reduced, we also see that the ability of NGOs and grassroots to provide their essential services is also diminished. Unless, of course, there is a clear clarification of what NGOs will have in the future and under what capacity. And we would really welcome such a clarification from the European Commission and the Greek government, and preferably as soon as possible, given that the centers are to become operational in the coming months. I believe the one on Samos will become operational very soon. To elaborate a bit further on the concerns that I've raised so far, I want to give you a very real-life, clear example from the field of education. Having myself taught high schools for many years, and also have experience teaching on the Aegean Islands to asylum seekers, I'm well aware of the fact that mental well-being is an essential precondition for learning. A child, a young person, basically anybody who's in distress has a reduced memory retention and reduced attention span. And this is neuroscientific fact. Another well-known fact is that in the current hotspot camps, self-harm and suicide attempts are common, are endemic even, among young people and even including young children. The pressures of life in the camp, of being trapped, these inhibit effective education. And it was a coalition of grassroots, of refugees, local civil society organizations that actually tackled this education challenge by establishing and staffing education centers outside of the camps. The very ability, the simple choice of being able to leave the camp, find respite in a place where people welcome you, treat you with dignity and respect. This enables well-being and in turn allows for effective education to take place. And now this is not just something that grassroots have invented. This is a best practice that UNICEF also adheres to. Now, this example raises several important questions. Firstly, how will effective education and the well-being of students, of young people, be guaranteed in the context of the MPRICs? Will, for example, school-aged youth be able to access education centers outside of the MPRICs? And if yes, how will this be enabled and guaranteed? And another very important question is how will qualified teaching staff be recruited and retained to work in these remote locations? We know from experience that this is very difficult. This is not an easy thing to do. And these questions, well, they will require answers if the right to education, the well-being and the best interest of children and young people are to be ensured. Now, this is just one example, and I could give you many more examples from different service fields. And well, I think, for example, of the importance of being able to independently reach a lawyer for legal aid, particularly if with the new so-called border procedures, if they will be introduced. But I'm aware as time is running short, so I'm going to try and wrap up. What I want you, the audience and panelists, to take away from everything that I've just said is that the concept of the MPRICs as it currently stands is fundamentally flawed. The inhumane and undignified living conditions that we have witnessed in Moria camp, that we are still witnessing in its successor on Lesbos, and also in the other hotspot camps, these are the result of a policy of mass containment of asylum seekers at Europe's external borders. And just like the hotspots, the MPRICs are a tool of mass containment. They will replicate the human rights violations and suffering of the past. If we truly want to have no more Morias, if we truly want to go beyond ad hoc solutions, then moving towards sustainable, dignified, and humane reception conditions means that we need to abandon mass containment at the borders for alternatives. The reality is, sad reality is at this moment is that planning and construction of the MPRCs is moving forward very quickly. This is also why it's very interesting that the one on Lesbos is called a pilot project, because things are moving very quickly and becoming reality very quickly. And this means that needs for essential services will arise and that these needs will need to be addressed. And in order to do so, the MPRCs and other reception facilities must be open facilities with independent oversight, monitoring, and accountability. Moreover, and this is very important, the meaningful and consequential inclusion of NGOs and grassroots organizations and refugee-led organizations into the development of the MPRCs is required. One of meetings, as we've had in the past months, they just don't cut it. And I'm almost NGOs and the refugee communities that live inside the camps, they must no longer be kept in the dark because their expertise is key to ensuring effective service provision and dignified living conditions. So it's important that we are heard, that civil society is heard and included in a meaningful way in discussions if we are to create safe and dignified reception conditions on the Aegean Islands, conditions that are most importantly in line with European values. I'll conclude here. Thank you very much.
Thank you so much, Matthias. And I will move us right on to a question. If I could ask you to please keep your answers to 1 minute. So the first is for Mr. Logotitis, and it reads, you said you were open to discussion, proposals, and visits. Does this mean that NGOs will be invited to work in the new centers on the Greek islands?
I heard Matthias as well. This is a joke for me. We work together with the NGOs on the Mavrovouni side every day. They are there. We talk, we have meetings. We address the issues and we solve them together. I don't understand this question at all. Of course, the NGO world will be there. The thing is that because there is a misperception, we should be in lead of all these things. We let it in the NGOs back in Moria. And the thing that we got as a result was different areas with different services, with different provisions and benefits to the beneficiaries. There was an area run by one NGO which had electricity. There was another area which had no electricity. So we have to have a more streamlined approach, a more homogeneous approach. And this is why we established the sectoral approach. We talked about legal aid. In the past, every NGO had a different office in the camp, so you could get legal aid shopping. Medically, the same. In Moria, you had 5 different medical offices, 5 different medical opinions. You didn't like one opinion, you went to the other one. Then you didn't like the second one, you went to the third one. You were shopping. That was what was happening. What we try to do is a sectoral approach. Everyone is invited to get inside, even in Samos or wherever. We have no problem with that, but they have to register.
Okay.
Because all the funding comes from the European Commission, and we have to do some monitoring and some auditing. We have to know with whom we are cooperating. Are they spending the money they get on a proper way, on a legal way, for the purposes that they say they are spending the money on? So these issues should not be addressed today. They should have been addressed 5 years ago. Unfortunately, the pressure was that high that no one addressed the issue. And now we have a lot of NGOs that applied to this registry. Yes, but this registry finds out that they don't have the basic financial tools to work.
Okay, thank you very much. I'll have to move us on to the next question, which is for Ms. Gminder. It's a question from an asylum seeker in Chios who is asking who is responsible for the protection of fundamental rights of individuals in the new centres, and is there an official role of the European Commission in the monitoring of how this takes place?
So thank you for having the opportunity to come in on the monitoring, because I also want to, what Mrs. Strick said, to want to be very clear. We are not implementing the new pact with this pilot project. We're working based on the current legislation, while we have suggested the pact as a way forward and a possible but a possible way of cooperating again between member states in an efficient manner. But we have seen the necessity to help with concrete solidarity on the ground immediately. And as I explained at the very beginning, I think it's very important to coordinate also more the EU side, because we're having many people involved, many people doing things, and we can be more effective if we're together. On the monitoring of implementation of EU law and also the operation of the multipurpose reception centers, obviously we will continue to be present from the task force and EU staff on the ground, because also now we have one person on the islands from the EU. We get feedback from you as civil society, from residents, and from Greek authorities, and they all play an important role. So we will operate on a continuous basis with the Greek authorities to ensure jointly adequate monitoring and supervision, and the supervision of the management of the center. We have regular meetings in the form of a steering committee. We include also the UN bodies in that, and as said, the EU agencies. And we have also regular monitoring reports being submitted under the grants we have been giving to the Greek authorities. So we are, as Mrs. Strick rightly said, the guardian of the treaty. So when we have evidence that we can bring to the Court of European Justice in Luxembourg, because if we have to go to court, we also want to have a case that we win this case. That's very important for us as guardian of the treaty. And therefore, we will continue to play this role and to act if necessary. Having said that, on the questions, Mrs. Strick, I want to use that occasion to apologize. They got a bit lost in my inbox, I think. So it's a personal failure here. And probably I've been too active on many other things, and we will answer to you. On the money used, this is also, I have to be very clear, while we're financing a lot in Greece over the past 5 years, we have also been financing a lot through the international organizations that have as co-beneficiaries quite a lot of the NGOs that are active on the islands and on the mainland. And we make all these grants public on our website. We have not yet signed the grant for the multipurpose center in Lesbos and Chios. We have signed one for Kos, Leros, and Samos. So that's important to clarify that. Thank you.
Thank you very much. One last question for Ms. Strick. Are you concerned that the Council will water down the screening proposal? Any specific points on that?
Yeah, thank you very much, and thank you also to Mrs. Gminder for her answers. And indeed, I would say that we could use also the pilot if in the screening regulation the reception conditions of the directive would also be applicable. About this question, indeed, what also Birgit Sippel said, there is a lot of skepticism and reluctance in the Council. This is what we hear from different member states on the screening regulation. It may indeed even be the case that we will face a deadlock in the end. I don't know to what extent it could be indeed the case that there will be a further watering down if it comes, for instance, to the safeguards that we see, that we have now, and maybe also the derogations from there. But to be honest, there are already a lot of, there's so much discretion already left. It's so rudimentary, actually, what is there provided, that I think that the member states may want to even have more derogations, so more discretion for themselves. Yeah, for sure, I think we will see that with all files in a new pact, that member states will try to have less obligations and more possibilities to do it in their own way. I cannot say concretely for what provisions I fear the most. Yeah, maybe I can say that I think if it comes to the monitor mechanism, I already hear that member states really, really don't like this provision at all. So we have to see if it will survive in the end, although we want to strengthen this provision. So, well, I'm not very optimistic in the end that we will have an independent and effective monitor mechanism on the basis of this pact.
All right, thank you so much for that answer, and thank you also for all the questions, and to the speakers for joining and for staying longer. There's clearly a very big appetite for discussion on this topic. And Matthias, we did have questions for you as well, and we'll try to ensure they get answered outside of today's meeting because we're way over time. So thank you very much to everyone, and we hope that this has provided a good platform for further discussions on this important topic. Thank you.
Thank you also. Bye.
Bye-bye.